Hi, I'm John Presvelos, and this is the Move Smartly podcast. When I started my brokerage Velocity Realty in Toronto back in 2009, I was always focused on mitigating risk in real estate transactions. And I know most people hear that and think, what risk? You just sign some papers and you buy a home. But the reality is that there are a lot of risks and potential problems that come up all the time in real estate transactions. And today's guests are going to walk us through some of the common issues that come up and how we as buyers, sellers, and agents can mitigate those risks. Sam and Evan Presvelos are lawyers at their boutique civil litigation firm, Prevelos Law. They're involved in a variety of residential and commercial real estate disputes. In short, they're often representing clients who are suing home buyers, home sellers, or real estate agents because of a home sale that didn't go as smoothly as just signing some paperwork. Sam was also voted among the top 100 lawyers in Toronto by Post Magazine for the past 2 years. So we're very lucky to have him and Evan join us today to share their insights with us. You can watch these sessions at our Move Smartly YouTube channel and learn about upcoming sessions by following us on Twitter. And if you have any of your own questions about the market or any feedback, send me an email at askjohn@movesmartly.com. And now on to our episode. All right, guys, welcome to the Move Smartly podcast and YouTube channel. It's great to have you. So today we have Sam Presvelos. Sam, hello.
Hey, good morning, John. Thanks for having us.
Absolutely. And Evan, thank you as well for joining us today.
Thank you, John.
Yeah, so as we talked, I think it'd be great for our listeners and viewers. What we really wanted to do today is kind of unpack some of the common pitfalls that happen in real estate transactions. And for me, I find this interesting because a lot of people look at real estate and they assume, well, you just sign the paperwork and you move on. And they don't see what you and I see, which are all the different problems and lawsuits that go on and the pitfalls. And quite frankly, this is a big part of my business too, because I'm paranoid about this stuff and I like to mitigate risk. And, when I talk to other brokers from firms, they tell me they get sued all the time. And I'm like, how the heck do people operate? Like, I have a heart attack when I'm getting sued every other week.
You should put us in touch with them.
I know. So we're gonna kind of go through a number of different themes, a number of different topics, and it's kind of circumstances that come up. But I wanted to kind of kick off with one that is kind of quite relevant today, and that is, buyers who are defaulting on the home that they bought, right? And this is happening in the context of maybe people who bought pre-construction homes. We're hearing this in the suburbs. They bought them from Mattamy. Prices went down. They can't get a mortgage. Or someone who bought a resale home and prices fell and they couldn't sell their current home. So maybe kind of walk us through at a high level what happens from the buyer's perspective if they go to close and like, I can't get a mortgage. What are the kind of the typical outcomes in that situation?
Yeah, so we deal with a lot of both breaches, both from a buyer and a vendor's perspective. The buyer's one is certainly more common in our practice area. And it can be a little bit tragic because the buyer's so excited to move into a new home and they've spent a lot of time looking at different properties with people like you. And then all of a sudden, because of a financing or another issue, they can't close. Buyers have to be really careful because one thing they may or may not know is anytime you put a deposit down on an agreement of purchase and sale that they've signed off on and has been accepted, that deposit's at risk. If a buyer can't go ahead and close the transaction, they're more or less should expect to lose that deposit unless there's a really good reason for them not to close that transaction. There's been a material breach of some sort. And the chances of a buyer getting a deposit back are very slim. Courts have found sort of anything between 5 to 20% of the purchase price is a reasonable size deposit. So there's certainly a liability in terms of, number one, losing your deposit. And the second thing buyers need to know, if for whatever reason they can't close or they're thinking about not closing on an agreement of purchase and sale, is the vendor has a duty to mitigate their damages. They don't have to wait around for you to get your stuff together, because I see this often in a scenario where a buyer has breached once, they're asking for an extension, they're trying to get themselves reorganized, go to a secondary lender. The vendor, after you've breached the first time, doesn't have an obligation to sit around and wait weeks and weeks or a month in some instances for you to get your stuff together. And the vendor's going to turn around, relist that property, sell it for a reasonable price in the market. And if there's a downturn in the market, that's very bad news. And if there's a delta or a difference between what you agreed to purchase that house for and what that vendor subsequently had to sell that home for, you're going to be on the hook for that difference. And it's not uncommon for that difference to be in 6 figures. So if you've paid $100,000 deposit, which is, I wouldn't say it's an uncommon size of a deposit in today's market, and you're looking at 200-300 upwards of a possible damages. And I would say, good luck trying to lower that, because in most cases it's probably pretty defensible from the vendor's perspective.
So the buyer's on the hook, and effectively what happens, I guess, is that obviously the vendor, whether it's a builder or a home seller, effectively sues that purchaser for the difference between what they sold and what the buyer agreed to purchase it at, right?
That's right. And to add on that, there's a recent case law that has come out that suggests that the deposit would actually go towards, or would contribute against the damage amount for the resale of the property. So that does assist the buyer in some ways, but at the same time, again, like Sam said, you are on the hook for the difference.
Go ahead.
Yeah, so I was going to say an additional thing that people should also know about if they find themselves in this situation is the vendor doesn't necessarily have to suffer damages. So for example, if you contracted to buy a home for $1 million and they subsequently sold the home to $1 million to another buyer because you couldn't close on a financing condition, that vendor is still entitled to keep the deposit.
Oh, really?
Right. Yes. So even if you resell it at the same price, even if you resell it at a higher price, let's say you can find an even better buyer for 1.1 million, you're still entitled to keep that deposit. It's not considered a windfall.
Oh, okay. Wait a second. Who's entitled to keep the deposit?
The vendor is.
The vendor.
Oh, really? Okay.
Right.
Yeah.
Even if they sold a house for a higher price?
Even if they sold it for a higher price, yeah.
The policy behind it, John, is that the deposit is considered a mechanism to incentivize the buyer to close. So so irrespective of whether they close or not, and like Sam said, even if the vendor does end up selling or reselling their home for a higher price, they would still be entitled to the deposit.
Wow. Now, do most of these cases go to the courts, or do they tend to get negotiated and settled before that, like for some kind of value in between the damages and some delta, some difference?
Yeah, I think it's we often tell our clients, litigation and decisions around litigation is really an economic decision. It has to be, you got to do a cost benefit analysis. How much money is it going to take for you to recover the damage versus what are you going to spend to recover? If the damage for a vendor, if we're representing a vendor, for example, and the damage is $50,000, there's a shortfall of $50,000 to the next buyer that they sold their home to, and it's going to cost them 75% of that to litigate. At some point you have to take a step back and say, there's a sweet spot here where we litigate, but at some point we have to shift to negotiating and resolving this, because going all the way doesn't make sense for anyone. Mm-hmm. Right? You don't want to be spending the same amount of money you're going to recover or close to, because in addition to the cost considerations in litigating, it's emotional. It takes time. Very rarely will your matter get resolved in under a year. The courts, at least in Toronto, are extremely backlogged. So these are all considerations that both parties, I'm sure, are thinking about when they're deciding just how far to take it. Yeah.
Awesome. That's super helpful. Now, I wanted to kind of move on and chat a little bit about something that we've both talked about, cases where homes have open building permits. It's a difficult one because, I've been in this industry for a long time, and I've heard different things from lawyers. Like, I've heard some lawyers say, well, that is not a reason to not close on the home. And some say it is a reason to not, from a buyer's perspective, right? So maybe, like, what are some of the examples of cases where, like, building permits are material and a cause for a buyer to say, forget about it, I'm not taking this home, and maybe examples like where it's not and they have to proceed with the deal if they found out about it after the fact?
Well, I think one of the most important considerations you have to give, John, is what is required to close the open building permit. And we're currently dealing with a situation where the buyer, there was an open building permit on the property, and the buyer, I guess, was not aware of what was required to close the open building permit. and it actually required significant construction to the property. And eventually, I think what happened was that the buyer ended up discovering that it was an impossibility to close it the way that the property was renovated, and so basically what would happen was they would have to, I guess, destroy a certain portion of the home. And so I think, I think that the buyer has to do their due diligence with respect to exactly what is required to close an open building permit before they proceed with the purchase.
Interesting.
I think that, we do see this from time to time. We've also seen situations where, not dissimilar to what Evan was describing, people did their own renovations. They didn't get a permit to do it. And they may, in one situation that we dealt with, they built a structure that they just didn't have a permit for. And that was problematic because the clients in that situation, they wanted to live in that additional structure. And when they want to move in, they get a knock on their door from city officials saying, this has never been permitted. It's not fit for occupancy. We want you to go and rip out your kitchen. We want you to go take out the plumbing. You need to show proof to us, basically, that nobody's living and it's not capable of being inhabited. I mean, this stuff happens at their cost. And one of the questions you have to ask, Evan's totally right. What's the cost to remediate or rectify those open permits? Is it even feasible? Like, commercially, practically speaking, is it feasible? And does it affect the intended use and enjoyment of your property? Because if it does, that's a pretty fundamental issue. And if a property, for instance, is advertised as having a live-in suite, and that's one of the reasons why you wanted to buy it, or having two dwellings and you wanted to do sort of a multi-generational home situation, that is a fundamental aspect of your agreement. And we think in that situation, you might very well have a good case for trying to, set aside the agreement of purchase and sale, because that's a fairly material defect. So you have to be careful. At the same time, I think there's a big sense of responsibility for real estate agents when they're negotiating these agreements of purchase and sale. As you know, on these standard OREA forms, there's an entire agreement clause. Mm-hmm. And if you think you're going to get a living suite that's capable of housing you or a family member or whatever the case might be, that better be reflected in the agreement of purchase and sale. Because it's going to be a lot harder to litigate a scenario where somebody made an oral representation or a representation in a listing and it never made its way into the agreement of purchase and sale.
Oh, okay. So that's an interesting point that you make. So if you buy a home, so your example, you buy a home and it has a garden suite as an example, but it was built illegally, right? And the city wants to knock it down or basically says you can't use it for that use. So what you're saying is it doesn't matter that the listing actually advertised it as a garden suite in a two-family home. To litigate, it would be important to have that reflected in the agreement of purchase and sale, right?
Absolutely. And why wouldn't you? If you know as an agent that it's an important component or important aspect or selling feature of the property, it takes you 5 minutes to put it into the APS. And if the other side wants it out of the agreement of purchase and sale, it's probably a red flag. You're going to ask yourself, why are they changing the wording or why are they crossing it out? If you're happy to put it on the listing, you should, one would imagine that you'd be comfortable putting in the actual agreement.
Yeah, and it's interesting. I mean, you probably don't even need a formal clause because in the agreement of purchase and sale, there's a specific standard wording section that says what is the use of the property. And most people just put residential, but a lot of the times when it's multifamily, we will put, two-family home or duplex or triplex.
Right.
I always used to put that even when I knew that triplexes were probably illegal. Again, putting it back to the seller, the vendor to cross that out, right? But if they're advertising as a three-family home, we're gonna make the APS as a three-family home. But I didn't realize that that it's quite that material in the context of litigating after the fact.
Well, the more certainty you have, the more, the more specific you can be in an agreement, I think the greater protection you're going to afford to your client, right? When you don't have certain positive statements or warranties or descriptions, you're dealing in the gray. And anytime you're dealing in the gray in litigation, there's risk. And certainly from our perspective, we want to minimize that. We would feel much more comfortable helping a client where they specifically put that this additional dwelling is zoned whatever and is capable of actually housing someone, as opposed to just saying additional dwelling.
Yeah,
I think that also goes both ways, right? Like for example, if a seller represents the house as being a multi-generational home, right, or having maybe 2 or 3 independent livable spaces, right, but legally they only have 2, or there's an open building permit with respect to the third portion of that property, right, as an independent livable space, that could also be considered a misrepresentation of the property.
Mm-hmm.
Right. So it equally applies to both the realtors as well. I mean, realtors representing the buyer as well as the seller.
Yeah, that's super helpful. So, okay, so then what it sounds like is open permits aren't necessarily a problem. They're a problem if closing them results in some material changes that need to be done.
That's right.
And inheriting massive deficiencies because it wasn't built to the permits or it wasn't done properly or something like that. But if it's really just about an administrative process of closing them, then it's not necessarily something to be overly concerned with, is what it sounds like.
Yeah, that's accurate. And Evan, we're dealing right now with a situation where, because of the permits that were open and either can't be closed or it takes a lot for them to be closed, it could affect other things like the insurability of your home.
Yeah.
Right. So there's sort of second order consequences sometimes to some of the more fundamental permits that can't be closed or that require a lot of work to get closed.
Yeah. So, I mean, interestingly enough, on our website, we actually pull building permit data from the city of Toronto. So in the city of Toronto, we show all permits for houses, open, closed, everything. I think going back to maybe 15, 20 years. And again, because I'm a bit obsessive compulsive and like to mitigate risk, and it's so we can see that. I mean, for those of you who aren't on our website, you should check it out at shamelessplug.com. But when we built that, the other municipalities in the GTA did not have that data available in an open data platform. I haven't checked recently if they have. So, what's involved a lot of times, I think one of the challenges is most people don't look at this stuff because, do you have to, like before Toronto had an open data thing, you have to drive down to City Hall, wait in line, see what's going on with the permits. It wasn't even just a phone call. Like in the past, you just have to go down to the city. And I wonder if that's one of the reasons why a lot of people just don't even think about this stuff when they're buying homes.
I think, if it's not practical to retrieve it, and if it requires a physical drive to some municipal office and waiting in line, I don't see that being something that a lot of agents probably think they have a responsibility of doing, or maybe some agents don't even know exactly where to go and find it, or whatever the case is. And especially in a hot market where things are moving really quickly, you have offer dates within, a week or maybe less than a week. It escapes most people's minds. I suppose one way you might deal with that is just having it as a representation in the agreement of purchase and sale, and trying to shift that burden onto the vendor. The vendor is in the best position to know whether there's an open permit or not.
Yeah.
Because presumably they would know it's their property and they would have been involved in getting that permit to begin with.
Yeah, and that's a good point. And I think that starts becoming more relevant. That a clause like that's relevant if you're buying a home, to me, that's newly renovated or relatively recently renovated or built or something like that, where the permits are kind of more important. If the home's been there for 20 years the way it is, I'm less concerned about open permits.
Right. Yeah, fair enough.
But you're right. And I think I was chatting about this with Evan about it. And as you said, Sam, in a market like Toronto, the reality is when there are bidding wars, not only do you usually not have the time to do all this due diligence because, places are taking offers 3 days from now. The reality is, just like you can't really, and fine, the market's a little slower today, but it's like almost half of the homes are still selling for over asking. They're getting bidding wars, right? So not only can you not win it with conditions on financing and inspection, but once you start throwing in these types of clauses, from my experience, stuff like, seller guarantees to close all building permits, even though the argument is the seller should know and not have to worry about it. It sort of like raises a red flag for sellers. It's like, I don't want to get sued. Let's not even look at this guy. I don't want headaches, right? Yeah. So sometimes even including it in situations where the market is competitive, the home's competitive, could potentially impact the buyer's offer if the seller's worried that, of getting sued. And yeah, but anyways, it's a tough market to compete in for sure.
That's a good consideration. And actually, just before we came on this interview, Evan and I were talking about sort of the intersection between wanting to do the due diligence that's required and that a litigator hopes you've done, but also at the same time being practical in current market conditions. And I think one of the questions that, buyers have to ask themselves is, how much risk am I willing to tolerate, given the profile of the property and maybe the information my agent's able to gather? For example, if it's been newly renovated, there's a higher chance. If it hasn't been newly renovated, there's probably a lower chance. And people assume risks all the time. Anytime you're putting in an offer that has no conditions, that's a big risk. But yeah, I guess if you live by the sword, you die by the sword, and you have to maybe put it in your budget in the back of your mind that there could be a surprise or two, and, budget for that accordingly.
Yeah. And that kind of leads us beautifully into kind of the next thing I wanted to chat about, which is, rights of way and easements. And for those people who don't know what that is, I mean, typically when you buy a home, you have your lot, you have certain boundaries, but sometimes a neighbor or someone might have some right or access over your land. And, when you talk about due diligence, I'll never forget when I got into this business, like, I don't know, 15 plus ish years ago or something like that. I remember we had a client that was looking at making an offer on a home and it didn't have a survey, and which is very common. I mean, most sellers don't have surveys. And then he called his lawyer and his lawyer said, never make an offer on a home if it doesn't have a survey, right? And I'm like, are you kidding me? Like, no, most people don't have surveys, and of course, like his position is good. Like, it's good to see the rights of way. I mean, this is the right due diligence, but going back to what you said, practically speaking, sellers don't have it. So, and my experience is, at least in the market now, like 80% of homes don't have, at least they don't make it part of the marketing. Like, the seller might have it in some box somewhere, but the survey is not advertised. So, maybe kind of walk us through some of the issues that come up because of that, because I can kind of see how when you're buying a home, if you don't know necessarily what rights you have or what your neighbor has over each other's property, or in some cases where the actual boundaries are, it can be problematic.
Yeah, it can be problematic, and it can lead to other types of litigation, neighbor fence litigation and boundary disputes, which oddly enough, in my experience, I have found that neighbor disputes are among the most acrimonious. People are very territorial when they come to their land. So it's something you definitely want to get clarity around. First of all, I would say that, I think certain types of properties are more likely to have these issues than other types of properties, right? Anytime you have sort of a laneway issue or common driveways, and it's kind of not clear where one person's driveway might finish and another person's driveway might end. So you might not necessarily have to say in all situations we require to see a survey, but I think depending on the property and where it's located, you're more likely than not to have an issue of the sort. And it could be very problematic. I remember there was a case where a buyer thought they had the driveway was a certain dimension, and it turns out the driveway was not the dimension that they visually inspected, and it was a much smaller dimension that impacted their ability to put the car in because the neighbor had a claim to a strip of land that would have interfered with the use and enjoyment of the driveway. And in that situation, the court, said that that's pretty material, and the buyers were entitled to back out of the deal. So depending on how fundamental that claim could be over your property, it could be a deal breaker. Having said that, there are easements that are common. I mean, hydro easements, so on and so forth. They're not going to interfere with the use and enjoyment of your property. But, you're quite right. It presents a problem that is similar to the sort of open permit issue. Yeah.
And is there any way, I guess, to mitigate it? I mean, from a buyer's perspective, how do you kind of, if you can reduce it? I mean, certainly I think most people have become very relaxed about that because, these days buyers get title insurance, which, in theory protects them, from these kinds of legal disputes. But, especially if it's kind of a material issue that impacts your ability to use the home and you find out about it after, I mean, obviously you want to avoid that, so, are there any great ways to kind of mitigate some of that risk, do you think?
I think it goes back to the agreement of purchase and sale. So the amount of, the number of situations I have come across where there has been a property line dispute or boundary or territory dispute, and the existing homeowner is unaware of it is very slim.
Mm-hmm.
Oftentimes, the existing homeowner knows there's an issue. Whether or not they investigate that issue, whether or not they disclose that issue, is a different consideration. But oftentimes they're aware. A neighbor has made a comment. They're fighting over, or they haven't previously thought about where the fence should be, or you're stepping on. It's rarely a surprise. So trying to get that information out from the vendor, having some sort of a representation in the APS, assuming there's no survey, is probably in a commercial sense the most practical thing you can do to protect that risk. I don't know if Evan has different thoughts, but
no, I believe that's right. And sometimes it also may happen in situations where, or at least it doesn't get discovered until, let's say, the new homeowner wants to renovate the property, right? And then I guess their neighbor is now reconsidering, I guess, we're kind of like, if they have a potential claim to part of the boundary, or maybe they're just unaware of what the boundary line is. And so then you have the situation where this new homeowner is trying to renovate their property and then discovers that maybe they don't have as much sort of, property area as they thought they did. But again, like Sam said, I think it all comes back to the agreement of purchase and sale. I do think, obtaining a survey is of like paramount importance to determine exactly sort of where your boundary line is and what, area of property you're entitled to.
Yeah, I mean, and I tend to agree with you. I mean, the way I've always found is the easiest for me to mitigate is when things don't look right, and you look at a lot of properties, things just don't look right, like where the fences are, where certain things are. I'll never forget, I was looking at earlier in my career, I was looking at a home, like it was on like a 40 by 110 lot, and we're looking in the backyard, and it felt like a football field. It was massive. And I'm like, this doesn't seem right. Like, this doesn't seem like 100-foot deep lot. Like, it's weird. And then only when I went to go look it up on the land registry, and the land registry shows you and this is an important thing for a lot of agents don't do this. It shows you the geographical boundaries, like visually, right? It's obviously not like a survey, but you could actually very clearly see like 30 feet of the back of the lot where technically they had the fence and it felt like their property is actually like an underground river that's municipal property. But because it's underground, they just put the fence over it and they use it as their own property, right?
Yeah, right.
And that's obviously like a problem if as a home buyer you assume that's yours. If you're planning on putting a pool in, well, that's not all your land right now, right? And obviously impacts their use.
Or if you're relisting it, and that's a feature of the property, and you've made a specific representations as to the property's dimensions as well, right?
Yeah, exactly.
So, well, I was just going to say, even from the perspective of the realtor representing the buyer, right? Like if they know that the buyer has a certain intention or intended use for the property, and let's say they wanted to get a permit to potentially buy or potentially build maybe like a second floor or extend the property in either direction, and then they've realized that on account of maybe obtaining a survey following the purchase of the property, they can't do that, right? They can no longer get a permit to do that. And so now you have a situation where the buyer can now turn around and sue their agent.
Mm-hmm.
And John, in your situation, is I think you raise another important consideration, which is the vendor's agent in that situation has an obligation to verify material facts about the property.
Yeah.
And if you're coming and doing an inspection and your client is telling you, well, I think these what the dimensions are, you should be doing a little bit of due diligence to verify whether those are in fact the dimensions. And I don't know how long it took you to go and pull that information. It probably didn't take you more than an hour, and that time is well spent, because it could lead to a very big headache down the road for everyone.
Yeah, I mean, it takes a few minutes. It's not even an hour. So, and that's interesting. So if let's just say I didn't do that, okay? And that buyer bought the property and they find out about it after, I guess in that situation, they technically would like sue everybody, like vendor, listing agent, their buying agent, like, because everyone had, I'm guessing, is that correct? Like everyone has some
that is correct. That's correct. That's correct. Because yeah, because they could sue the vendor for misrepresentation in terms of obviously the the square footage of the property, right? Yeah. They can then sue the their own realtor right? For not doing the due diligence. And, if they had known, like I had mentioned before, what their, intended use for the property was, and now they can no longer, do that, then they can sue their own agent. So you're right in that assessment that, there would be liability that would fall on multiple parties in that situation.
And just taking a step back, in any given residential real estate transaction, there's a finite set of considerations. I mean, they're not infinite, and basic due diligence to confirm that you are buying what you see should be a no-brainer for most people.
Yeah,
and especially where if you have like a ravine lot or whatever the case might be, and people are acting, or they're trying to pass off the ravine as additional value, and they're fencing part of that ravine space, and you think you're buying part of that. I mean. Yes. Right away, your mind should probably go to see whether or not that's something that they can actually convey and something that they in fact own.
Yeah, and that's a good point. And a lot of times listing agents will put in some sort of clause like in one of their schedules that basically says that the buyer agrees to accept title with the fence and everything the way it is, and the seller makes no representation or warranty regarding whether the fence is on the lot boundary and so on and so forth, right? And sometimes that kind of, is a bit of a red flag, because if you're the buyer, you want to know what you're buying for sure.
Yeah.
Awesome. That's super helpful. Now, I wanted to chat a little bit about, again, something else that kind of comes up in real estate. And this kind of deals with, what we often call like representations and warranties regarding the condition of a home. Like, what does a seller needs to disclose? What do they not need to disclose when they're selling a property? And what happens, obviously, if things come up between, the time they bought and the closing.
Yeah, so I mean, if there's a warranty in the agreement of purchase and sale, and that warranty, let's say, has been breached, right? Someone gave a warranty about a certain component of the home, and it turns out just not to be true. It doesn't entitle the buyer to set aside the contract, but it could entitle you to damages. So you would still have to complete the agreement of purchase and sale, go through with the closing, but you reserve your right to sue for damages, whatever those might be as a result of the breach of warranty. In terms of what has to be disclosed or not, I mean, anytime a buyer is most often represented by an agent, and it's going to be assumed that the parties are relatively sophisticated because they have an agent representing their best interest, presumably. And so, typically we kind of divide issues into two categories, patent defects and latent defects. And, sort of the patent defects are things that you can see, or things that can reasonably be discovered by somebody who does a home inspection. And if you waive a home inspection, you have a bit of a problem. Because if you were given the opportunity to do that and you decide, and this is not something I want to do, I just want to close, make my offer more competitive, you're going to have a much harder time substantiating the fact that you're entitled to some damage on the breach of a warranty about something in the house. If it's a latent defect, the circumstances in which that needs to be disclosed, because obviously a latent one is not something that's visible to your eye, and in some situations might not even be discoverable by a standard home inspection. There's only a real duty there to disclose if it goes to the health and safety of the home, or if it goes to the intended habitation of that house. So if there is something like termites, if there, a home could have been used for marijuana grow up or something like that, maybe the current buyer is not aware of it. Both of those things could be problematic in the future. And by the way, both of those things have important health consequences associated with it. That's when the vendor needs to do the right thing and make that disclosure proactively.
Interesting. So basically then, if a home has, so you said something that was interesting. I thought that you said that if it's something that can reasonably discovered with a home inspection, you don't have to disclose it. So in theory, if a home has, and this is common, for example, in the East End, where homes might have insulation around, hot water rads that are asbestos, or asbestos in their attic, right? Where a reasonable home inspector would see that and say, yes, I'm pretty sure this is asbestos, you should get it tested. So that technically does not need to be disclosed because that's visible, right? That is something that a home inspector can spot. But if a home has termites as one example, or some ongoing water leak that happens, 3 times a year when it's a torrential rainfall. So those are things that are latent and in theory should be disclosed by the seller, right? Is that kind of generally correct?
Yeah, and I think the asbestos, it really sort of depends on the location and stuff, because I mean, if for some reason it's in a part of the home where maybe it's not discoverable or couldn't be discoverable by some sort of, basic due diligence when you're buying your home, then obviously asbestos presents a health and safety risk to the home and to the users in the home, right? And that's also something that people should keep in mind, because as you know, there are certain time periods where asbestos is more likely to be have been used in a home rather than the most obviously more recent ones. So
Awesome. Interesting.
I think there is a little bit of murky water when it comes to sort of latent defects, though, right? And the reason why I say that is, if it's a latent defect that obviously the seller or the vendor isn't aware about, right? And there's obviously no obligation to disclose because they don't know, what it is, right? But what happens in a situation where somebody's willfully blind about a latent defect, right? And let's say they did notice something maybe some time ago, but they made really no effort to sort of, follow up and maybe figure out exactly, where is this water coming from, or is it, symptomatic of maybe a larger problem here with my home, right? And I mean, that's obviously, getting into sort of a gray area that might be a little bit fact specific. So I think, kind of sellers, rather, vendors should be aware of certain situations like that. And, if they are, or they do notice something, they should, do something to kind of investigate, or the source of that problem, right?
So one thing that comes up a lot in real estate transactions are vendors selling a home in what we call as is condition. So maybe you can kind of tell us what that means, and it sounds like for the average person in the industry that the vendor's trying to contract out of any need to disclose anything about the home. Rights of way or latent defect or anything, quite frankly. So maybe if you can kind of unpack what the risks are or how that's used and what they can contract out of, if anything.
Yeah, so I mean, well, as is conditions, probably first and foremost a red flag for anyone. Unless, although I suppose sometimes it's not. Maybe in a very hot market, there's just no time. It's so competitive. Things are moving at such a fast pace that it's just done for expediency rather than that they want to hide it. I think the as is probably fact specific. On the one hand, when you're accepting a tremendous amount of risk, obviously, as a buyer, when you're signing something like that, the immediate defense is going to be you've waived your right. Buyer beware. You had the opportunity. Nobody coerced you. You wanted to get the deal. The market was competitive. You would have probably done the same situation on another home. There's nothing the specific vendor did to you to induce you, so on and so forth, right? Those are attractive arguments. Having said that, I think if there's some pretty fundamental issues with the home, it could be arguable, right? Like if there is something very fundamental, let's say a latent defect that, like we just talked about, really goes to health and safety of a home, and something that basic wasn't disclosed, I'd be curious to see how the court might deal with that, just from the consumer protective sort of perspective.
That's interesting.
Yeah, but obviously any agent who has a client who's going to buy on an as-is basis should have it documented somewhere that, hey, there are risks. Number one, you understand what those risks could be. There could be a lot of surprises that might have a material impact, both on the use of the home and on any plans to renovate that home. And probably, I think the smart thing for an agent to do in that situation is make a recommendation that they speak to a lawyer about what the consequences could be of getting themselves in a situation like this. Because at a minimum, if something goes sideways, the agent has a record saying that, look, we advise you that there's risks. We've advised you that you should do an inspection. You didn't want to do it because the market was competitive. We get it. But here's a chain of us telling you to do this. And by the way, we told you to go to speak to a lawyer. Whether or not your client does that is out of your control. But what's in your control is the type of advice you give and the warnings you give to your client in that situation.
Yeah, that's interesting. So I mean, and you're 100% right. Not just the lawyer. From my experience, even talking to their mortgage broker, because some lenders don't like as-is condition clauses in the APS, and it's a massive red flag for them. So it could even impact the financing, and they'll probably get financing, but maybe at a higher rate because their preferred lender won't do it. The one time I think it is quite common to see these and less of a red flag, I'd say, is cases where the home's an estate sale or a power of attorney is selling it. And from my experience, usually people do that because the person now responsible for the sale has never lived in the home, so they can't disclose what they don't know, right? But having said that, you're still, it's a red flag. But I agree with you. For me, if I'm looking at a home that is owner occupied, the owner lives in it, and they're selling the home as is, it is a massive red flag to me, because it's like, why would you do that? I normally would just delete it, because sometimes I've noticed sometimes agents will have that as like a template clause. They'll squeeze it in, like, they'll squeeze in a clause that says the buyer, and it's very sneaky. They'll squeeze in a clause that says the buyer agrees to accept, all chattels and fixtures, including stove, so blah, 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 and the home in as is condition. Right?
It's like one of these is not like the others. yeah.
No, but I'm not even exaggerating. Like, they'll actually do that, and like it, because a lot of buyer agents don't read those clauses because they're kind of boilerplate. They're very common, so they scan them. So unless you actually read it, you don't realize you're buying the home as is. So it's like, cross that out and then see if it's an issue with the buyer or the vendor. But anyhow, that's quite funny. So last thing I wanted to ask you guys about, and it comes up, I mean, it's kind of related to disclosures, is something called seller property information statements, which, I mean, you don't see a lot of these days, but some people still put them. Maybe kind of talk through what they are and what the risks are from the seller's perspective, and how to deal with them from the buyer's perspective.
I'll let Evan speak to that, because I know he's dealing with a pretty contentious SPIS situation right now. I mean, I would just say, in short, if you don't have to do it, I probably wouldn't do it. It's an invitation for risk, because generally the more things you say, the more things somebody can hold you accountable to. But yeah, Evan, you can go ahead and kind of walk through this one.
Yeah. So I think these, the buyer definitely has to be careful with respect to, first of all, how the relationship between the SPIS and the agreement of purchase and sale. And I'll give you an example of that is, like Sam had mentioned in this.
Let me hit pause before we go there. Maybe just walk through what the SPIS is, just generally, for people who aren't familiar with it.
Sure. So an SPIS is a disclosure statement that's rendered by the vendor. And it just makes a series of disclosures with respect to the property. So for example, whether there is an open building permit, or whether there's an occupancy certificate that's been that has been obtained with respect to the property, things like that. And so to go back, you have to kind of understand sort of how the relationship between the agreement of purchase and sale and the SPIS. And if an SPIS is provided by the vendor to the buyer prior to the purchase of the home or entering into the agreement of purchase and sale, if from a realtor's perspective, right, and you're representing the vendor, you would want to include in the agreement of purchase and sale that the disclosures that are made in the SPIS statement, right, are included in the APS.
Interesting.
And the reason why I say that is because there could be a situation where you have the SPIS that was disclosed prior to entering into the APS, and the entire agreement clause in the agreement of purchase and sale, right, does not make reference to the SPIS. So an argument could then be made, I guess, by the buyer, right, that the SPIS was not included as part of the agreement of purchase and sale, and might say that those disclosures didn't actually take effect into the agreement. However, if an SPIS is disclosed after entering into an agreement of purchase and sale, then the seller can rely on that to enforce and basically tell the buyer, well, you were aware of this, irrespective of what's in the entire agreement clause, because the SPIS was made and was disclosed after the parties had entered into, or had entered into the contract, right? Sorry.
But how can you make the disclosures after the agreement? It kind of seems backwards for the average buyer.
It's odd, and yet sometimes it happens where disclosures are made from the time period after the agreement of purchase and sale is signed until closing. and you're still in this relationship with the vendor in that time period. So things that are said or done in that time period are actually could have some pretty important legal significance to both parties.
But what happens if the disclosures lead me as a buyer to say, well, I didn't sign up for that. I didn't know you had this issue. I want out of the deal now.
Well, yeah, and I mean, the problem is if the entire, as you know, in most AREA standard form agreements, there's an entire agreement clause, right? Mm-hmm. And that's only applied retrospectively to things that happened up until the point in time in which you signed that agreement. If new things become discovered after that, or representations are made after that, those can become enforceable. Because the entire agreement clause is not prospective, it's not future oriented, it's backwards oriented. So everything you might have said or discussed, basically gets omitted unless it's part of that agreement. But going forward, you can't make a warranty or representation or say something about that property and then rely as a default to the entire agreement clause, because it doesn't work in a future oriented way.
So you're basically saying any verbal representation or warranties or anything that's said before the agreement is signed kind of doesn't matter if it's not in the agreement, correct? Is that kind of generally what I'm understanding?
Yeah, because it's going to be excluded by the entire agreement clause, right? And the idea being that whatever is actually in the agreement of purchase and sale is the final deal between the parties. I mean, there are always, situations where that are exceptions to the norm. I mean, there's recent case law in the context of commercial lease agreements, for example, where entire agreement clause are rebutted by certain representations and there is a duty between two parties. I mean, it's not a hard and fast rule, but the general point is, representations, warranties, discussions that predated the APS are going to be very hard for you to turn around and rely on account of that entire agreement clause.
Interesting. Yeah, so that's a good reminder why we always wants to kind of put those clauses into it to protect, I mean, at least from a purchaser's perspective, to protect them.
And be careful what statements you make after about the property, because if you want to continue having a discussion and making representations about the property after the agreement of purchase and sale is signed, again, it's an invitation for possible liability, because if it turns out to be untrue, and again, we're talking about the time period between the APS to sign and closing, you're now inviting the buyer to hold you accountable for statements you're making about that property.
Interesting. That's super helpful. Awesome, guys. Well, thank you so much for taking the time. I don't know if there's anything else you wanted to touch on before we wrap up today.
Well, I think that the parting comment I would leave with is a lot of the issues that transpire in whether residential or commercial real estate transactions are ordinarily things like I would actually consider them matters of common sense. The problem with common sense, of course, is in the context of a commercial, I'll say it's not that common, but in the context of a deal, things are moving so quickly that people seem to be fixated on price or fixated on the opportunity or fixated on the finance. And a lot of very basic steps of due diligence, for whatever reason, become blurred in the periphery. And it's just important for everyone in the process, whether it's the agents or the parties themselves, to slow down, because this is one of for most people, the biggest transaction of their life. Yeah. And the fact that it's happening on a standard form, and most agents or some agents might not be putting exactly what should be there, or that their clients are hoping and expecting to be there. It doesn't take that much time. And, I think that people need to take a step back, really think about the due diligence. What does my client think they're getting? Are they getting that? And what problems do I think could compromise or jeopardize what they think they're going to get in this home?
Yeah, and just to kind of supplement that, even from I guess like the realtor's perspective, and like we excuse me, and like we discussed earlier in today's podcast, is do your due diligence even as a realtor, right? And maybe not necessarily just rely on sort of statements that that the vendor has told you or your client has told you, and go get the documentation, go get the survey, and make sure that the representations that you are making are accurate, right? So in order to avoid situations where you might be liable for and brought into the mess that might seemingly be between just the buyer and the seller. Yeah.
No, that's a great point. And certainly that resonates with me, because, even in our business, you're right. A lot of times, we'll go out and look at a property and we'll have a buyer say, let's make an offer like right now, like go home, prepare it. Like there's not like 3 days of due diligence to do research. And, you know, I always tell my agents too, like you have to, like you said, hit pause, even if it's for half an hour, right? Like you're not going to spend 3 days researching a home, but the common things that you're worried about that might be problematic that you can do some research on, you know, you have to do before you jump into it to mitigate that risk. And certainly, like if you're in an area where it's hard to get building permit info, stuff like that, you can't do that. The buyer just accepts that risk. But when you can have that data or find it, I think it is important to hit pause. So that's a very good point.
Yeah.
Yeah. The other thing I was going to mention is like, even for a realtor, maybe create a checklist for yourself.
Yeah.
Right. About, you know, maybe some, you know, things that might be commonplace to certain properties or condos or whatever the case may be. And just make sure that, you know, you kind of, you know, dot your I's and cross your T's with respect to your due diligence.
I think that's a great idea. Having a checklist or something like that. Then you put yourself in a position where you say, I have a standard practice of.
Yeah.
And if a lawyer ever asks you, well, what's the proof of the standard practice? So it's like, well, here are some considerations I have every time I'm representing a buyer. Here are the considerations every time I'm representing a vendor, right? It's not going to be 100%. You can't anticipate every scenario. Not every scenario is going to lead to liability, but having something is much better than having nothing.
Yeah. Awesome, guys. Well, thank you so much for taking the time to join us today and share some insights from complicated legal issues that come up in real estate transactions. So thanks again, Sam and Evan, for taking the time today.
Yeah, it's our pleasure. Thanks, John, for having us.
It's our pleasure. Great to be here, John. Thank you.